Although the 2010 rules have come into existence, the provisions of some of the existing laws continue to be relevant for the wetlands that are covered within their area of jurisdiction. These include the Wildlife Protection Act of 1972, which applies to wetlands within protected areas of national parks and wildlife sanctuaries, the Indian Forest Act of 1927, the Forest Conservation Act of 1980, and the Environment Protection Act of 1986, which apply to wetlands within protected or notified areas, and the Environment Protection Act of 1986 will also apply to wetlands outside protected or notified areas. Insofar as the role of the public under the rules is concerned, this has been slightly problematic because the rules do not recognize traditional rights over wetlands. There is no representation of the local and indigenous peoples in the authority, and there is no involvement of the public in the process of identification and notification of wetlands. The rules only provide that the general public can make a representation once the central government invites objections and suggestions on the authority's recommendation to notify an area as a wetland. In addition to the 2010 wetlands rules, we also have legal frameworks existing at the state, city or local level which are relevant. For example, we have the East Kolkata Wetlands Conservation and Management Act of 2006, which applies to the East Kolkata wetlands in Kolkata and establishes the East Kolkata Wetlands Management Authority. This authority, in addition to having representatives of the different government departments in the state, provides for one representative of the Institute of Environmental Studies and Wetland Management, two nominated representatives of non-governmental organizations, as well as one representative of fishermen cooperative societies. At a city level, we have the Guwahati Water Bodies Preservation and Conservation Act of 2008, which applies to wetlands in the city of Guwahati which are notified for protection. However, no authority has been established under this act. In addition, at the state level, we have a Kerala Conservation of Paddy Land and Wetland Act of 2008, which applies to the state of Kerala. Again, no authority has been established under this law. Now, let's come to some judicial decisions relating to wetlands. One of the milestones in wetland protection is a 1993 decision given by the Calcutta High Court. The name of the case is People United for Better Living in Calcutta versus State of West Bengal, and it concerned the protection of a Ramsar site in the eastern fringes of the city of Calcutta. Now, in this case, the High Court highlighted the need for balance between developmental activities and environmental protection, in a sense, sustainable development. And the court said that there is no doubt that wetlands act as a benefactor to the society, and encroachment in wetlands would be detrimental to the society. According to the court, the benefit to society, and I quote, cannot be weighed on mathematical nicety so as to take note of the requirement of the society. What is required today may not be a relevant consideration in the immediate future. Therefore, it cannot really be assessed to what amount of nature's bounty is required for the proper maintenance of environmental equilibrium. As a result, the High Court stayed all development activities at the site of this wetland. Another important decision, again from the Calcutta High Court and involving the same petitioner, came in the year 2008, and this is the case of People United for Better Living in Calcutta versus East Kolkata Wetlands Management Authority. This case concerned the East Kolkata wetland which we discussed just now. And in this case, the High Court permitted the construction of a water treatment plant in the wetland. However, it required that the water treatment plant construction take place in the most eco-friendly manner, and remedial measures must be undertaken in the vicinity of the area. The court also appointed a monitoring committee to ensure that its directions were complied with. The National Green Tribunal has also been actively involved in dealing with the threat posed to wetlands by industries, real estate developers, etc. I'd like to discuss two cases here. One is a case concerning the activities of builders and others in the Dadri wetlands, also known as the Bill Akbarpur Wildlife Habitat, which is home to the protected blackbuck species, nilgai, as well as over 200 migratory and resident birds. In this case, the National Green Tribunal has restrained construction in and around the wetlands. In another case concerning the construction of a school and real estate development in the Dhirpur wetlands in Delhi, there was release of sewage or sludge in and around wetlands, and this has been restrained by the National Green Tribunal. In addition, the NGT has directed the Ministry of Environment and Forests and the Delhi government to identify and assess the status of wetlands in the capital and to submit a plan for their conservation and management. A brief note about the plans and policies concerning wetlands in India. One of the earliest plans is the National Wetland Conservation Plan from 1985-86, which led to the creation of guidelines for conservation and management of wetlands in India. However, there has been serious non-utilization of funds provided under the plan, partly due to lack of interest from the state governments. Last year, in 2013, this was replaced with the National Plan for Conservation of Aquatic Ecosystems. In addition, the National Environment Policy of 2006 also highlights the need for a legal regulatory mechanism for protection of wetlands from degradation. In addition, the more recent National Action Plan on Climate Change from the year 2008 also recognizes the importance of wetlands in the context of climate change, and specifically the National Water Mission under the National Action Plan on Climate Change lists some actions for conservation of wetlands. Now, the National Water Mission is in some respects far more progressive than the provisions of the 2010 wetland rules, because it calls for the formulation and implementation of a regulatory regime to ensure wise use of wetlands not only at the national and state levels but also at the district level, which may provide an opportunity for community participation, which has been criticized as being missing from the 2010 wetland rules. In addition, a 2011 decision of the Calcutta High Court, in which the High Court directed the state government to formulate a wetlands and water bodies policy, has led to the creation of the West Bengal Wetlands and Water Bodies Policy of 2012. In conclusion, just to recap, what we've learned in this presentation is firstly that the Constitution of India includes certain duties which have a bearing on wetlands regulation. We do not have a specific act on wetland regulation in the country, but we have the 2010 wetland rules which provide for protection of certain wetlands and also permit certain activities in certain situations. At the international level, we have discussed the Ramsar Convention in detail, which again includes what is known as the Ramsar list, which provides for the protection of the wetlands included therein. We also have legal framework comprising certain laws at the state and the local level which also protect wetlands in certain situations. Finally, we have a number of policies at the national level and also some development at the state level which may prove crucial for the protection of wetlands in the future. Thank you.